Greetings creators, welcome back to my channel. Today we're continuing from chapter 21, Money versus Wealth. America's Hope, also Trinidad and Tobago's Hope by Thomas Schaft. Bankers know the difference between money and wealth. If you can print money, you can buy everything in America, including the media, through advertising, money, and ownership. You can buy judges, sheriffs, and Congress by political contributions. If bankers control the media, they control the Congress and the information Americans hear. Wealth is anything that you can sell. You can sell a house, car, farm, business, gold, silver, coins, promissory notes, bonds, stocks, and investments. Most people sell their 40 hours a week for a payroll check. Yes, labor produces wealth. Houses, cars, farms, roads, factory goods, food, gas, and services are produced by labor. Why is it illegal for a counterfeiter to counterfeit money and lend it out? The counterfeiter would obtain nearly all the wealth of the nation for free without using a gun. The counterfeiter gets your labor for free as you work to obtain money to repay the loan, or the counterfeiter forecloses and gets your home or car for free. Counterfeiting and stealing both result in obtaining the victim's wealth for free. One uses a suit and tie as he prints money and lends it out, and the other one uses a gun. The bank gets the borrower's promissory note for free. He then deposits the promissory note, making it money, and returns the value of the money promissory note to the victim as a loan. The bank got your promissory note for free. The bank gets your labor for free. And if you fail to repay the loan, the bank gets your home in foreclosure for free. The minute the bank deposits your promissory note and gets your promissory note for free, the banker's wealth is increased and your debt is increased by a simple bookkeeping entry. If the bank lent other depositors money and the money was returned to the one who funded the loan, no theft or wealth transfer would take place. But instead, the bank gets new money for free and returns it to you as a loan. Now the banker gets your wealth for free by making you work for the banker to repay the loan, or by foreclosing and getting your home or car for free. Debtors are the banker's slave. Only slaves work for free. The banker needs you working to produce food, cars, gas for the cars, homes, roads, bridges, bank buildings, and services. Then the banker gets a free ride by printing money and getting your production for free. Who has the biggest building in town? Often the banker does. The banker knows that if everyone stopped working and stayed home with a money-making machine, everyone would have piles of millions of dollars in their living room. If the farmer, grocery worker, and gas station attendant stopped working to print money, there would be no food or gas to buy. Everyone would starve. If everyone had to work and could only barter food for gas or a car for a motorcycle, the bankers would have to produce wealth to survive. The banker could not print money to get your wealth, gas or food or car for free. If we have no money and could only barter, the problem would be corrected. If the banker could not print money, he would have to work like everyone else. He would have to build a house and barter one house for another house. Why should you have to work to produce wealth, but the banker can obtain wealth without working, by printing money and getting a house for free? Why does the counterfeiter go to jail, but the banker creates new money and sits on the board of directors of the church and local businesses? It's because the banker is smart enough to not print cash and go to jail. The banker prints money as bookkeeping entries, non-legal tender like a casino prints casino tokens. so it is not technically counterfeited, but he gets a benefit similar to counterfeiting. The banker gets the benefit without going to jail. To stop the banker, you have to sue him for breach of agreement, and the banker knows that few understand how to explain it in front of a jury. The banker is smart enough to give part of the spoils or booty to the preacher, judge, sheriff, lawmakers. This money keeps the banker's secret a secret and keeps the banker's money making machine going. Bankers give advertising money to the media, and the media has bank loans. Banks can control the media but by advertising and loan money. Without it, the media is out of business. Many in power want to correct the system, but fear if they speak up, the bankers will heavily fund their opponent next election and have the media swing the election in favor of the bankers' candidate. Judges and politicians alike profit from the secret banker system through investments. They get foreclosure properties before the general public does and make huge profits. One judge bought foreclosure properties amassing a 8 million fortune in a few years. You guessed it. He, he was a foreclosure judge. The judge helps the bank and the bank helps the judge. They call it good business. Others call it dirty business. Politicians use computer-generated buy-sell signals on investments, making huge profits, all because of the secret banking system. The preacher wants the bankers tithe money and loan money, and they fear that if they condemn the banker, the tithe will stop. The bank will foreclose on the church and the preacher is out of business. The preacher puts the banker first and God second. This is idol worship. The bank controls the church instead of God controlling the church. The bank controls the government instead of the voters. The CPA needs bank loans for his clients and he gets new clients from the bank. The CPA says nothing so that he gets paid for his fees. It is all about profit and depends upon secrecy. The banking system cannot continue without the help of politicians. For a price, politicians help continue it to their benefit and profit. Their God is money and the love of money. We have a political party who will join us if we distribute enough emails and put up enough websites to get the truth out to the voters. Voters will join us if they know that we can win. And we can win if you help us get one American to join at a time. The bankers use deception and we must use the truth to win. The key is the vote. Politicians have a price. Give them enough money and they change their views and sell their vote to the highest bidder. You can never trust anyone who will sell their vote to the highest bidder. Even if the current politicians change the banking system, you cannot trust them. They have proved to us that they will sell themselves to the highest bidder. What else will they do to you? We need honest people in government. We need politicians who represent the people and not the bankers or special interest groups who steal our wealth, our rights, and our liberties. Bankers use deception and we use the truth. Please help us by hosting a website or by getting out emails to bring people to the website. You can help us make a huge impact for the freedoms we deserve in America. We have a political party that will join us if we get the websites up and emails out. When we have converted enough Americans to the truth and it is safe, then they will join us. Please help us make it safe to correct the problem. Help us convert the voters to the truth. You can have the government you deserve. But if you do nothing, you deserve to have your children be the bankers' slaves. Or you can help us to set your children free. You really can make a difference. Join us while we have the freedom to correct the problem. Your job and money mean nothing if they take your freedoms away or manipulate the money supply and create a bank-induced depression for their future profits. The time to act is now. Help us save America and get out the truth today. Chapter 22. Expert Witness. An expert witness has special skills and knowledge. in a certain area such as banking. The expert assists legal counsel in determining the court strategy. The expert knows the strengths and weaknesses of both the plaintiff and defendant. Most people think it is the primary responsibility of the expert to testify. It is not. In Chicago, I testified for nearly 10 years. My primary job was to give courtroom strategy and show legal counsel how to crush their opponents. I was known for showing legal counsel what questions to ask their opponent that would destroy them no matter how they answered. You want the expert for the other side to agree that you are correct. The banker's strategy is to make sure you are bankrupt or lose your house so that you will have no money to sue them with. I believe their goal is to make sure most people do not have enough money to hire an attorney or an expert witness. Experts do not take a percentage of the win. You pay them huge fees before they walk into court. My strategy is to train you just like I would train a CPA to be an expert witness. I have trained about 2,000 CPAs nationally. Part of the course gave the CPAs expert witness training, so I am qualified to train you and your legal counsel. The first thing you must do is obtain all the literature from the opponent. In this case, it is the Federal Reserve Bank publications. I have already done this, studied them, and given you the information you need. The next thing is to understand the information. I have carefully explained it in this book. Having had years of experience in banking and knowing how to train you to exploit the bank's weaknesses and minimize your own. I will then show you how to use CPA expert witness arguments to ask the questions that give the bankers witnesses the sweats. The beauty of filing a lawsuit is, if the case goes to a jury trial, and if the bank defends it by bringing in a CPA expert witness, the expert must know everything and cannot say he does not know or understand. My goal is to train you to take on their expert witness, discussing the agreement and exposing the truth. If you can get the bank's expert witness to agree you are right, you may not need to hire an expert. If you hire an expert witness, the bank will have a strategy. You pay thousands of dollars to hire and schedule an expert for trial. The bank delays the trial. You still have to pay the expert. The bank delays trial several times until you are out of money and can no longer hire the experts. If you are trained like an expert, you know how to question the banker's expert and turn him to your advantage. The banks will not know whether you have read this book or my second book with many more questions. This book does not have all the court strategy that you need, but it shows you the basic fundamentals of banking. My goal is to teach you some of these fundamentals and expert witness procedures. You may wonder why I repeat myself so often in this book. It is to give you first-hand experience of the kind of repeat a jury needs to hear. The more they hear something, the more believable it becomes. The more evidence and the more witnesses repeating the same information drums the point into the people's head. My goal is to win Americans to the truth. It is possible you may not have any choice but to defend yourself in court. If that is the case, I want you to tackle their experts and win the argument. People have taken the information in this book and charged others thousands of dollars for it. You are getting it for the cost of the book. I have been the leader in researching this subject. The others are following me. Always remember that courtroom strategies constantly change. Many of the people following me are using old strategies that may not help you. I am concerned that people will claim they know me, that they talk to me often, and that I will be their expert witness if I am needed, when in fact I have never heard of the group or individual and may not actually endorse the group. Please be wary of people using my strategies or claiming they know me to entice you to give them a fee. Every 3 months, my leaders have a new letter from me. This letter will enable you to know who my leaders are. I suggest that you work with the genuine leaders who have my latest information and not the others who are only reading the book and do not have my most current strategies. Once you have the CPA expert witness training, you can argue with political parties and neighbors or conduct seminars. This book and volume 2 plus all my cassette tapes for leaders and distributors will teach you the CPA expert witness type of training that will give a banker or his expert witness nightmares. I encourage you to contact me and become a distributor or leader so that you will have the latest strategies. Once you understand banking like an expert witness, you may decide it is easier to spend your time doubling your money every 6 months instead of fighting in court. If you and your friends could quickly obtain tens of millions of dollars, the money could be used as a political solution to regain our rights, freedoms, liberties, and constitution. Wealth in a country that is not free is not real wealth. 23. False witness, form versus substance. Before an attorney can sue, he must show that the defendant party breached the agreement. The attorney needs a witness to give testimony that there is an agreement and that the agreement has been breached. If Rich testifies in court that there was a loan when he knew that there was only an exchange of equal value, Rich would be given false testimony and would be called a false witness. In a normal court foreclosure, the lender does not come to court to give testimony. The bank attorney uses the alleged promissory note with the alleged borrower's signature as the witness in court to claim that there is an agreement, that there was a loan, that the lender fulfilled his agreement, and that the alleged borrower did not fulfill the agreement to repay the money. Instead of the attorney using Rich to give oral testimony, the attorney uses the promissory note as the witness and as the evidence to sue the alleged borrower. There is a legal concept of form versus substance. The form is the promissory note, which says that the lender lent money to the alleged borrower. The substance is the money trail, the book, keeping entries. The substance shows that there were two loans exchanged, equal value for equal value. The borrower was required to repay his loan to the bank, plus interest, but the bank never repaid the debt it owes. IOU was exchanged for IOU. The two newly created IOUs cancel each other. Substance, true transaction, shows that the borrower was the lender to the bank. Then the bank repaid the loan from the borrower to the bank. The form, the alleged bank loan agreement, shows the opposite. Example, you sign a paper that says you will lend 10,000, but no one lent you 1 cent to obtain the promissory note. A thief stole 10,000 worth of diamonds from you, sold them for cash, and returned the cash to you as a loan. The form says that there was a loan. Your signature also says that there was a loan. The true transaction, though, proves that there was no loan. The substance, the money trail and the bookkeeping entries proves that someone took something of value worth 10,000 from you, exchanged it for a different asset of equal value, and returned your 10,000 to you as a loan that you now have to pay off with interest. The attorney sues you claiming that your signature proves that you received the loan. You hire an expert witness to prove that there was no loan, that the substance of the true transaction was an exchange, and that you were charged as if it were a loan. Economically speaking, what is the difference if a stranger received 10,000 worth of diamonds for free, and if he got a 10,000 lien on your property for free, and if he received 10,000 of your future payroll checks for free? The substance of the transaction is the transferal of 10,000 of property from you to the stranger for free. The transfer of wealth is precisely how bankers obtain liens on the nation's homes, cars, farms, and businesses for free. If a robber were to use a gun to transfer your wealth, you would place him in prison. If a banker does the same thing by using form, an attorney, a judge, and a sheriff, you think it is legal. Does the attorney use the promissory note just like a witness to give false testimony in court, claiming that the lender lent money, cash or cash equivalent, to the alleged borrower? The attorney could be disbarred for bringing fraud into the court. The substance was an exchange of value for value. If the form and the substance disagree, you must rely on the substance over the form because substance always wins over form. Example: you give Rich 100 for 5 boxes of toys. Rich says, "Here are the 5 boxes. Sign this paper that says you received the boxes." You sign. Rich refuses to hand over the 5 boxes and claims that the form, the paper you just signed, says that you received the boxes. You would tell the judge that you acted in good faith by signing because you were told that you would receive the 5 boxes standing in front of you. After you had signed, Rich refused to let you have the boxes. The form, the paper, says that you received the boxes, but the substance, the true transaction, clearly shows you never received what you had bargained for. If the attorney uses the form paper in court to claim that you received the boxes when in fact he knew that you had never received, then the attorney brought fraud on the court to sue you. The form, the paper, would be a false witness against you. Is the promissory note used as a false witness? The promissory note has the borrower's signature agreeing that the lender lent the borrower money. Few people disagree that the one who provided the original funds to fund the bank loan check should be repaid the money. Few argue that we should have equal protection and full disclosure. The lender concealed the true substance in the agreement. If a banker receives 10,000 of capital from Joe and deposits the funds into a checking account, should the bank return the 10,000 to Joe? If all bankers agree that the answer is yes, then all bank loans in America should be canceled tomorrow. If the bank received 10,000 from Joe and lend the same 10,000 to Joe, should the bank return the 10,000 to Joe? The foreclosure attorney must argue that the bank should not return the 10,000 to Joe. Joe believed that the alleged borrower should repay the lender, and the lender should repay the one who funded the bank loan check. The foreclosure attorney must argue that the parties agreed to the terms and the one who funded the loan should never be repaid the money. How could the judge rule in favor of the bank, claiming that the one who funded the loan should never be repaid the money? Imagine faxing that ruling to everyone in the nation. The attorney wants only the form, the promissory note with your signature as a witness in court. You want the true substance, the true transaction, and the whole truth and nothing but the truth. Without the masses of the people joining, you will remain in debt. We need you to join in copying and in distributing the brochure. Keep in mind that the signature on the promissory note is always used as a witness against the borrower to create a situation in which the borrower automatically incriminates himself, self-incrimination. Some attorneys object to allowing the bookkeeping entries entered into court as evidence. The attorney must rely on the form and stop the substance. Extortion occurs when the court does not allow information into court for one's defense. How does one get the substance into court? One needs a CPA expert witness to bring the substance into court. There are ways to get past financial statements of banks that have gone out of business even up to 10 years ago. The CPA expert witness needs to use notices and bank financial statements to prove substance over form. Obviously, bankers may read this book, so the secret for the expert witness cannot be revealed here. However, you can expect the judge and bank attorney to attempt to stop the CPA expert witness from testifying. I believe that the CPA's testimony could disbar the attorney. If your CPA testifies, the bank needs to bring in an expert witness itself to counter your experts. Now you have 600 questions from Volume 2 to ask the bank expert witness. I do not believe the bank expert will want to testify knowing that you have 600 questions that he must answer. What would happen if 200 people in every state were committed to copying and distributing 3 brochures every day as they went to the gas station and the grocery store? Just 3 brochures a day calculates to 1 million brochures distributed every month. How long would it take before attorneys decide to join us and stop foreclosing? If you were an attorney and believed that 5% to 10% of the population will learn the truth, would you continue to foreclose? What if you believed that it was just a matter of time before everyone would find out and would want justice, and you could be disbarred? Would you stop working for the bankers and join the people? Brochures are very important to winning the nation. Without the masses joining, you will remain in debt. We need you to join in copying and distributing brochures. When the politicians believe there are enough voters to vote them out of office, the politicians will vote in Tom Schauf's banking solution or be voted out of office. At that time, the politicians will listen to the people and turn against the bankers. Chapter 24. The Witness Stand. There is a hypothetical illustration which represents a combination of real court cases, depositions, and interviews with bankers that I have witnessed. The banker was placed on the witness stand and sworn in. The plaintiff's borrower's attorney asked the banker the routine questions concerning the banker's education and background. The attorney asked the banker, "What is Court Exhibit A?" The banker responded by saying, "This is a promissory note." The attorney then asked, "Is there an agreement between Mr. Smith, borrower, and the defendant?" The banker said yes. The attorney asked, "Do you believe the agreement includes a lender and a borrower?" The banker responded by saying, "Yes, I am the lender and Mr. Smith is the borrower." The attorney asked, "What do you believe the agreement is?" The banker quickly responded saying, "We have the borrower sign the note and we give the borrower a check." The attorney asked, Does this agreement show the words borrower, lender, loan, interest, credit, or money within the agreement?" The banker responded by saying, "Sure it does." The attorney asked, "According to your knowledge, who was to loan what to whom according to the written agreement?" The banker responded by saying, "The lender loaned the borrower a 50,000 check. The borrower got the money and the house and has not repaid the money." The attorney noted that the banker never said that the bank received the promissory note as a loan from the borrower to the bank. He asked, "Do you believe an ordinary person can use ordinary terms and understand this written agreement?" The banker said yes. The attorney asked, "Do you believe you or your company legally own the promissory note and have the right to enforce payment from the borrower?" The banker said, "Absolutely, we own it and legally have the right to collect the money." The attorney asked, "Does the 50,000 note have actual cash value of 50,000? Actual cash value means the promissory note can be sold for 50,000 cash in the ordinary course of business?" The banker said yes. The attorney asked, "According to your understanding of the alleged agreement, how much actual cash value must the bank loan to the borrower in order for the bank to legally fulfill the agreement and legally own the promissory note?" The banker said 50,000. The attorney asked, "According to your belief, if the borrower signs the promissory note and the bank refuses to loan the borrower 50,000 actual cash value, would the bank or borrower own the promissory note?" The banker said, "The borrower would own it if the bank did not loan the money. The bank gave the borrower a check, and that is how the borrower financed the purchase of the house." The attorney asked, "Do you believe that the borrower agreed to provide the bank with 50,000 of actual cash value, which was used to fund the 50,000 bank loan check back to the same borrower, and then agreed to pay the bank back 50,000 plus interest?" The banker said, "No. If the borrower provided the 50,000 to fund the check, there was no money loaned by the bank, so the bank could not charge interest on money it never loaned." The attorney asked, "If this happened, in your opinion, would the bank legally own the promissory note and be able to force Mr. Smith to pay the bank interest and principal payments?" The banker said, "I am not a lawyer, so I cannot answer legal questions." The attorney asked, "Is it bank policy that when a borrower receives a 50,000 bank loan, the bank receives 50,000 actual cash value from the borrower, that this gives value to a 50,000 bank loan check, and this check is returned to the borrower as a bank loan which the borrower must repay? The banker said, I do not know the bookkeeping entries. The attorney said, I am asking you if this is the policy. The banker responded, I do not recall. The attorney again asked, do you believe the agreement between Mr. Smith and the bank is that Mr. Smith provides the bank with actual cash value of 50,000, which is used to fund a 50,000 bank loan check back to himself, which he is then required to repay plus interest back to the same bank? The banker said, I am not a lawyer. The attorney said, did you not say earlier that an ordinary person can use ordinary terms and understand this written agreement? The banker said yes. The attorney handed the bank loan agreement marked Exhibit B to the banker. He said, is there anything in this agreement showing the borrower had knowledge or showing where the borrower gave the bank authorization or permission for the bank to receive 50,000 actual cash value from him and to use this to fund the 50,000 bank loan check which obligates him to give the bank back 50,000 plus interest? The banker said no. The lawyer asked, if the borrower provided the bank with actual cash value of 50,000, which the bank used to fund the 50,000 check and returned the check back to the alleged borrower as a bank loan check, in your opinion, did the bank loan 50,000 to the borrower? No. The banker said no. The attorney asked, if a bank customer provides actual cash value of 50,000 to the bank and the bank returns 50,000 actual cash value back to the same customer, is this a swap or exchange of 50,000 for 50,000? The bank replied, yes. The attorney asked, did the agreement call for an exchange of 50,000 swapped for 50,000 or did it call for a 50,000 loan? The banker said, a 50,000 loan. The attorney asked, is the bank to follow the Federal Reserve Bank policies and procedures when banks grant loans? The banker said yes. The attorney asked, what are the standard bank bookkeeping entries for granting loans according to the Federal Reserve Bank policies and procedures? The attorney handed the banker Fed publication Modern Money Mechanics, marked Exhibit C. The banker said, the promissory note is recorded as a bank asset and a new matching deposit liability is created. Then we issue a check from the new deposit back to the borrower. The attorney asked, is this not a swap or exchange of 50,000 for 50,000? The bank said, this is the standard way to do it. The attorney said, answer the question. Is it a swap or exchange of 50,000 actual cash value for 50,000 actual cash value? If the note funded the check, must they not both have equal value? The banker then pleaded the Fifth Amendment. The attorney asked, if the bank's deposits liabilities increase, do the bank's assets increase by an asset that has actual cash value? The banker said yes. The attorney asked, is there any exception? The banker said, not that I know of. The attorney asked, if the bank records a new deposit and records an asset on the bank's books having actual cash value, would the actual cash value always come from a customer of the bank or an investor or a lender of the bank? The banker thought for a moment and said, yes. The attorney asked, is it the bank policy to record the promissory note as a bank asset offset by a new liability? The banker said yes. The attorney said, does the promissory note have actual cash value to the amount of the bank loan check? The banker said yes. The attorney asked, does this bookkeeping entry prove that the borrower provided actual cash value to fund the bank loan check? The banker said yes. The bank president told us to do it this way. The attorney asked, how much actual cash value did the bank loan to obtain the promissory note? The banker said nothing. The attorney asked, how much actual cash value did the bank receive from the borrower? The banker said 50,000. The attorney said, is it true you received 50,000 actual cash value from the borrower, plus monthly payments, and then you foreclosed and never invested 1 cent of legal tender or other depositors' money to obtain the promissory note in the first place? Is it true that the borrower financed the whole transaction? The banker said yes. The attorney asked, are you telling me the borrower agreed to give the bank 50,000 actual cash value for free and that the banker returned the actual cash value back to the same person as a bank loan? The banker said, I was not there when the borrower agreed to the loan. The attorney asked, do the standard Fed publications show the bank receives actual cash value from the borrower for free and that the bank returns it back to the borrower as a bank loan? The banker said, yes. The attorney said, do you believe the bank does this without the borrower's knowledge or written permission or authorization? The banker said no. The attorney asked, to the best of your knowledge, is there written permission or authorization for the bank to transfer 50,000 of actual cash value from the borrower to the bank and for the bank to keep it for free? The banker said no. Does this allow the bank to use this 50,000 actual cash value to fund the 50,000 bank loan check back to the same borrower, forcing the borrower to pay the bank 50,000 plus interest? The banker said yes. The attorney said, if the bank transferred 50,000 actual cash value from the borrower to the bank, is this part of the transaction? Did the bank loan anything of value to the borrower? The banker said no. He knew that one must first deposit something having actual cash value, cash, check, or promissory note to fund a check. The attorney asked, is it the bank policy to first transfer the actual cash value from the alleged borrower to the lender for the amount of the alleged loan? The banker said yes. The attorney asked, does the bank pay IRS taxes on the actual cash value transferred from the alleged borrower to the banker? The banker answered no, because the actual cash value transferred shows up like a loan from the borrower to the bank, or a deposit, which is the same thing, so it is not taxable. The attorney asked, if a loan is forgiven, is it taxable? The banker agreed by saying yes. The attorney asked, is it the bank policy to not return the actual cash value that they received from the alleged borrower unless it is returned as a loan from the bank to the alleged borrower? Yes, the banker replied. The attorney said, you never pay taxes on the actual cash value you receive from the alleged borrower and keep as the bank's property. No, no taxes paid, said the crying banker. The attorney asked, when the lender receives the actual cash value from the alleged borrower, does the bank claim that it owns it and that it is the property of the lender without the bank loaning or risking 1 cent of legal tender or other depositors' money? The banker said yes. The attorney asked, are you telling me that the bank policy is that the bank owns the promissory note, actual cash value without loaning 1 cent of other depositors' money or legal tender, that the alleged borrower is the one who provided the funds, deposited the funds the bank loan deposited to fund the bank loan check, and that the bank gets funds from the alleged borrower for free? Is the money then returned back to the same person as a loan, which the alleged borrower repays when the bank never gave up any money to obtain the promissory note? Am I hearing this right? I give you the equivalent of 50,000. You return the funds back to me and I have to repay you 50,000 plus interest? Do you think I am stupid? In a shaken voice, the banker cried, saying, all the banks are doing this. Congress allows it. The attorney quickly responded, does Congress allow the bank to breach written agreements, use false and misleading advertising, act without written permission, authorization, and without the alleged borrower's knowledge to transfer actual cash value from the alleged borrower to the bank and then return it back as a loan? The banker said, but the borrower got a check and the house. The attorney said, is it true that the actual cash value that was used to fund the bank loan check came directly from the borrower and that the bank received the funds from the alleged borrower for free? Is it true? It is true, said the banker. The attorney asked, is it the bank's policy to transfer actual cash value from the alleged borrower to the bank and then to keep the funds as the bank's property, which they loan out as bank loans? The banker, showing tears of regret that he had been caught, confessed yes. The attorney asked, was it the bank's intent to receive actual cash value from the borrower and return the value of the funds back to the borrower as a loan? The banker said yes. He knew he had to say yes because of the bank policy. The attorney asked, do you believe that it was the borrower's intent to fund his own bank loan check? The banker answered, I was not there at the time and I cannot know what went through the borrower's mind. The attorney asked, if a lender loaned a borrower 10,000 and the borrower refused to repay the money, do you believe the lender is damaged? The banker thought if he said no, it would imply that the borrower does not have to repay. If he said yes, it would imply that the borrower is damaged for the loan to the bank of which the bank never repaid. The banker answered, if a loan is not repaid, the lender is damaged. The attorney asked, is it the bank policy to take actual cash value from the borrower, use it to fund the bank loan check, and never return the actual cash value to the borrower? The banker said, the bank returns the funds. The attorney asked, was the actual cash value the bank received from the alleged borrower returned as a return of the money the bank took, or was it returned as a bank loan to the borrower? The banker said, as a loan. The attorney asked, how did the bank get the borrower's money for free? The banker said, that's how it works. Volume number 2 has hundreds and hundreds of questions with explanations about why these questions are asked. Each word is important, and many people change the questions to their demise. There is an art to asking questions. Legal counsel will be able to take these questions and be sure they are worded in a manner that can be asked in court. These questions were worded for textbook purposes to illustrate a point. 20, Chapter 25. How credit card companies trick you. The front cover of Reader's Digest, January 1997 reads, how credit card companies trick you. I think Reader's Digest left out the trick that enslaved Americans. Many of the credit card companies, according to the research I found, create money and loan it out to you. Instead of recording a promissory note as a bank asset, they record the credit card purchase and your alleged agreement to repay it with interest as a bank asset. Are they magicians that they have such power to trick us? If the agreement is good for America, why do they have to conceal the whole truth? Are they afraid that people will vote them out? Senator Bob Dole was one who advocated a balanced budget amendment. However, he appeared in a commercial during the 1997 Super Bowl game pushing the cashless society. I wonder who is paying him. Whose side is he on and why does he not advocate full disclosure? When we question our US representative about our banking system and his best response is, quote, what would we put in its place? End quote. Don't you wonder if perhaps you have spent more time studying the all-important banking system than he has? Now all credit and debit cards create money, but I believe not all credit and debit cards create money, but I believe most do. Americans owe 1.2 trillion in credit card debt. Nearly 60 million households owe an average of 60,000 on their credit cards. Chapter 26. America's newest jokes and favorite sayings. What did Lincoln and Kennedy have in common? Bank profits skyrocketed when they were killed. What is the difference between a license to manufacture money and a license to steal? Nothing. Who has a license to manufacture money and loan it out? Banks. What bank expense is never shown on the statement of income and is essential to keeping the banking system operating? Owning the best politicians money can buy. Local banks don't loan legal tender, they manufacture non-legal tender and loan it out. Do you know what bank robbery is in reverse? A bank loan. Why do banks hate the US Constitution? Constitutional money, gold and silver, prohibits the banks from getting your property for free and calling it a loan. What is the difference between a banker and a politician? The banker gets your wealth for free and gives part of the spoils to the lawmakers to make it legal. What is the proof that bad money drives out good money? You're broke, aren't you? Do you know how the bank stole the government? The Federal Reserve Note created the government bankruptcy. The bank stole my government. The borrower is the slave to the counterfeit lender. What historical figure wanted to hang bankers? Martin Luther. Do not hang anyone unless they are tried in a lawful court, convicted, and sentenced. Guess what real Americans are calling banks? Money changers. Do you know why the average American cannot get out of debt? You loan the bank the money for the check and they refuse to repay you. Hitler and Stalin would be proud of our Congress. The KGB and Gestapo would have loved the cashless society. What is the difference between the KGB and Gestapo compared to police seizing citizens' property and receiving bonuses for seizures? I don't know. Will you accept unlawful money today? Will you accept non-redeemable notes issued from a private bank? You just did. Real Americans only use cash. Cash means freedom. Using credit cards is voting to be a slave in a cashless society. Using a credit card is a vote for your future slavery. If the banks paid their debt, I would be out of debt. Do you know how Rockefeller got so rich? His family got Congress to pass a law so his bank could buy 100 for 2.5 cents. Anyone doing that would be filthy rich. If I could create money like the banks, I would be filthy rich too. What is the best kept secret in America? Banks can create money like counterfeiters, except they are licensed to do it. If one person stole all the property from the other, 260 million Americans, and returned the value of the stolen property back to the victims as a loan, who would be rich and who would be poor? What is the difference between doing this and counterfeiting to obtain liens on nearly every home, car, farm, business, etc.? It's the same thing. Do you know why bankers love Congress so much? They made it legal for a private organization to create money. What government is bankrupt because they let a private bank create money and then loan this same money back to the same government at interest? The American government. What country would do this? If you want a 100,000 bank loan, you give the bank 100,000 for free. The bank returns your 100,000 back to you in the form of a bank loan check. And then you have to repay the bank the loan. Would you agree to this? This is why bankers love Americans. All right, brothers and sisters. We're going to stop there for today. We reached chapter 27, short stories. Thank you for your time and patience. Remember, strength in body, powers in mind. Stay up.